I am a lawyer, but I am not necessarily your lawyer. The materials discussed in this podcast are for informational purposes only and should not be deemed legal advice. If you have a specific legal question according to your circumstances, then I encourage you to speak with an attorney licensed in your jurisdiction. Welcome back to another edition of Ag Law Today. Very excited about today's guest, all the way from Iowa. Is it Sumner, Iowa, Pat?
Yep, Sumner and Volga City are where we've got offices. So
the great Sumner, Iowa. How many people live in Sumner?
About 2,100 if everybody was home. Yep.
All right. So we're going to talk all things farm estate planning today. Pat, why don't you introduce yourself to our listeners? Tell us a little bit more about you and your law practice.
I am a lawyer to support a farming habit in Northeast Iowa. Married to my law partner, and she and I run a general practice, non-county seat practice in rural Iowa. And that means we do a lot of different things. Work with a lot of farmers, do a lot of estate planning and business stuff, but we run the gamut. Jill does a lot of divorces. We do 400 tax returns a year. We do bankruptcies, we do litigation, everything except like personal injury, workman's comp, and some of those boutique stuff. We refer that out, but otherwise we try to help everybody.
So let's talk the big picture on farm estate planning. And I feel like farm estate planning is oftentimes confused with succession and transition planning and also business planning. So how would you really explain the differences and also the overlap between those three concepts?
So I think that, the farm business itself is just like any other business, whether it's a shoe business or whatever, and there's got to be a way for it to survive. Whether or not that is sold to a third party or sold to junior is really where farming starts to get a little blurry, a little different. Transition planning is the act of moving in the next generation, getting them the skills that they need in order to be successful at the next level, moving them from tractor operator to equipment manager to equipment owner, for example. That's a transition planning stage. And then estate planning is your overall, this is all my pieces of my kingdom, this is where I'm going to fracture them, this is where they go. So to me, that's kind of those, they're integrated. They're not quite a hydra, they can live separately, but they're certainly, a lot of times they're just multi-headed beat on the same beast.
So it probably depends a little bit from client to client and situation to situation, but do you recommend that they all happen at the same time, or does one go before the other?
Well, I think that they're on parallel tracks with one another. You have to be able to be observant of what's happening in all three of those areas in order to make an effective plan. For example, the moving the next generation in, obviously that's a skill set you've got to be able to perform, and then once you have the required skills to be a member of that company, then we talk about how you'd raise the capital to acquire that. Moving the transition from one generation to the next is different than a business succession plan. Business succession is, how does this business survive? Can it continue to add more ground? How do I take on more partners to capitalize it? And things of that. So they run with each other. Then obviously the estate plan has to be there to say, well, if you're checking a grain bin and you hit a crust and you fall in and they don't get you out in time, what happens when you're gone? And that's another piece of it.
So Pat, walk us through a little bit of the process. Let's say you have farmer Joe sitting in your office who's like, okay, Pat, it's time, I need to get an estate plan. What are the tools that are available to that particular farmer?
Well, okay, so I think first thing is that you got to determine if Farmer Joe is really Farmer Joe, if it's Farmer Joe and Jane has been lifting heavy stuff all along, and who's all a decision maker in that process. And then once you identify who owns the assets and who's making the plan, what are their goals? What do they want to see happen? That's a default to think that everybody wants their kids to take over their farm. There's a lot of kids that don't necessarily, anymore have that automatic desire take over the farm. So we need to identify your goals and then how they match up with the people you want to foist your goals upon. And then from there, we've got to look at the different ways and avenues you can get them down in the next generation, or to expand enough to the point where it makes sense that another party wants to be involved. So you've got to look at what your cash flow is, what are your resources, what are your abilities. A 68-year-old who's in good health and doesn't mind checking hog barns is a different kind of partner than a 68-year-old with CPOD and who goes to Florida for 6 months every year in order to avoid Iowa taxes. So knowing what you've got as assets then is the first kind of step. And then from there, you've got to look at how do we achieve these things. To me, there's so many different facets, whether it's tax implications, whether it's family dynamics and politics. One of the graphics I like to use when I do my talks is they're juggling. And when you juggle, you can't get everything to be at the apex. You need to decide what's going to take a hit and what is going to be at the absolute best. So, for example, tax planning. There may be a great way to do something from a tax standpoint, but it ends up with nobody owning anything. Well, then that ball can't be at the top of tax benefit, can't be maximized, but we can delay the hit or modify the hit on taxes and still achieve some of your other results. And then the other thing I like to point out is within those results or those areas that you're looking at, which ones of these balls that you're juggling are lead, and if they fall, they're going to break your foot. Which ones are crystal, and if they fall, you can't fix, and which one of them are rubber balls. And, okay, we didn't quite get that 80 acres bought down the road that we wanted, but that's a rubber ball. There'll be another 80 that comes back around. We can get that back in the juggling rotation here. So
I love that juggling analogy, and I know that you reference that in your book, which I know that I forgot to include in your introduction, but you wrote the field manual. What's the complete title, Pat, and where can people get that book?
It's Field Manual, Iowa Farmer's Guide to Legal Issues. I think you can still get on Amazon. I know I can still order them and ship them out too. That's not a problem. And it's a companion volume is the one that you wrote for New York, and I think that one's Field Manual, a New York Farmer's Guide to Food. You got some food law in there though too.
Yeah, it's a little bit of food, but it's for legal guide for both farmers and food entrepreneurs. But Pat, I love your book, and I definitely love the juggling analogy. So let's talk a little bit more about those goals, because if Farmer Joe comes into your office and he brings Jane, and you realize that they have different goals, how do you address that?
Well, I think that's not uncommon that sometimes it's on the drive to the office here or at the office that you really get people to peel back and kind of explain, well, this is what I think. And it's about, and sometimes it's mother or father's treating maybe one of the failure launch kids differently in the plan than the other one wants to treat them. And so you kind of have to work through that and see to make sure that really you can come to what their consensus is. A lot of times they start with positions that seem in opposition to each other on how they're going to deal with the girl that never left the house. But in the end, they generally do want the same thing, which is to treat people equitably. And I like to remind people that fair is what happens the third week of August in Des Moines at the state fair.
That's funny.
Yeah.
You've always been good little, you're absolutely right on that. And what do you tell your clients when they're really concerned about fairness being equal for the heirs?
Yeah, and equity is how people want and generally are treated. The basic example I use is that if I've got parents with both male and female kids, I say, well, you didn't buy the son a prom dress, did you? And that's a real quick example that they can get behind and say, oh yeah, you're right. So we treat people as they need to be treated. And some of us need a warm hand sooner in life than others need. And others, you can give them other opportunities. And some people have gone to the First National Bank of mom and dad quite a bit. And other ones have not filled out the loan application yet. So maybe they've got some balancing issues. I try to avoid having the secret book that's in mom's cupboard with everybody's ledger balances in it, because those get lost. And then that creates a whole other set of drama. I think it's better to document and keep all that stuff. If you're going to be lending money, then make that a separate thing than have it in some sort of equalization in the will that in my house somewhere, there's a blue book with a ledger, and that'll give you the current balances anybody owes me and deduct it from their share. That's tough, especially when the person that owes the most money lives with them and takes care of them when they're dying, and then suddenly the book's gone. So we try to avoid that. But we try to get people to look and say, okay, Jim is a successful TV broadcaster. He probably, realistically, no matter what he's been telling you, can't come back and operate this 240-acre farm because he lives in a different state. So, but your daughter, Jane, she's already in operation. She's got her own standalone operation just down the road, and she's at 500 acres, and she could probably buy this and incorporate it in the operation. As a matter of fact, you're already pretty much hiring her to do your custom work anyway, aren't you? Yeah. Okay, so this is a natural transition. Yeah. So really, maybe we ought to look at removing the friction between Jim and Jane on how this asset gets transferred over. And then I start talking a little bit more about that, using the 3 Ps on a contract of priority, who gets to buy first, pricing, and then payment. Those kind of things, people find those as, they like seeing that as the thumb on the scales of equity. They can kind of balance things out a little bit more with that too. So.
I just want to make sure everybody's on the same page. So let's talk about the legal mechanisms with farm estate planning. I mean, I think everyone's sort of heard of a last will and testament, trust. There's different types of powers of attorney depending on the state. There's powers of attorney of property and healthcare in Illinois. I know in New York, where I used to live, they used to be called healthcare proxies, living wills, and things. Quickly, what's the big difference between a living will and a trust?
Okay, so a living will, at least in Iowa anyway, that's really nothing more than, hey, don't keep me alive until, just because some intern up at Rochester figured out how to keep me alive. If there's no medical reasonable certainty I'm going to live, then you can pull the plug. Now,
I misspoke. I meant a last will and testament.
Right. So a will and testament is a, hey, this is my stuff. This is where it needs to go. You're going to need to handle it through the probate court because it's titled in my name, and it can't be transferred to anybody else's name until you clear my debts and you settle up my accounts and move me on down the line.
And by the way, I just wanted to say that the word living will, and I think last will and testament, obviously I just made the mistake, but I think that those two things are oftentimes confused as well.
Absolutely. That's a probate process, and that exposes there's a tax from the court. There's going to be involved. It's going to take a publication in the paper. There's an inventory that is public record, and some people aren't keen on that. So what they look at is this revocable trust, or a living trust, as sometimes you hear those words thrown around. That I try to explain to people is like Clark Kent and Superman. It's still you. It's just a different version of you. And then once you're dead, that's when the trust then overcomes you and becomes a different creature, a different company, if you will. And a trust separates the responsibility for managing an asset, the trustee or the person in charge, from the fun of spending the money, which is the beneficiary. So it's a will substitute because you put your stuff in a trust and you titled it in the name of the trust didn't die when you died. Go ahead.
Let's talk a little bit more about the probate process. What are some advantages in skipping that probate process? I know that you mentioned less fees, right? Because there's fees going through probate. What are some other advantages?
For a lot of people, they're interested about the secrecy of it, that it's not a public record. Now, farmers, and especially in Iowa, you can tell who's got wealth by flipping open a plat book and looking at things that way. So it's not quite as attractive as, say, I don't know, maybe some of your New York clients that are heavily invested in stocks and bonds, when they can keep that shielded from the public eye. But the trust allows to split the use of an asset too that people find attractive. For example, for the next 20 years, it's going to be managed, and you can get the rents off of it, but you can't get ownership to it. You can't leverage or sell that asset. But then at the end of that 20-year term, I think you'll be old enough and mature enough by then to own the asset, so I'll let you have it then. So trust provides some dead hand control, which people find enticing sometimes.
Pat, if a farm is getting federal farm payments, or they're involved in federal farm programs, are those payments halted during the probate process?
No, they're not. You can have actually the probate. I just talked to an FSA official the other day. She's got a probate estate that's been open for 14 years.
What?
Yeah, got some mineral payments in another state that keep lingering on, but every 2 years you got to tell the FSA why it's still open. You have to. They call it the 2-year letter, and you can continue on. The one advantage, since we're in the rabbit hole of the FSA, if a trust has ground in CRP, then it's usually when someone dies, you can void the CRP contract and get it back out and sell it again as production ground. When the trust didn't die, though, the trust still has the contract, so you can't get out of those CRP contracts, which is how they view life estates too. If a life estate holder who has the authority, we'll touch on that in a second, but the life estate holder enrolls something in CRP, that contract continues even after the life estate holder dies, and the remainder men can't get out of it. So there's some particular things you need to look at when interacting between estate planning and the Farm Service Agency.
So Pat, just last week, this was not for a farm client, this is actually for a friend of mine in New York City, but I transferred the shares of her LLC. She's got several LLCs for real estate investments into basically her family trust. So now the trust effectively owns these 3 LLCs. And I'm curious, do you recommend that for some of your farm clients if they have LLCs or corporations that the ownership units would be transferred to the trust?
Yeah, there's some advantages to that. You got to be careful on how those LLCs are taxed. I think there's some problems if you have an S corp style LLC that's held by a trust. There's some disadvantages there. But yeah, it's another layer of protection. There's this crazy chart we use once in a while, and I've got to tell you, most of my clients don't prefer to get that crazy, but you can have a piece of ground that is owned by an LLC, which is owned by a trust, and then designates a beneficiary. And then you can have that LLC that owns the ground, rent that ground to another operating LLC, which then splits the operation into the day-to-day management and then a marketing LLC beyond that. So you can split the income 6 or 7 different ways, with these different formations. And then if you're the creditor trying to get after the beneficiary, it's, I don't know. No, I'm the beneficiary. Well, what are you the beneficiary of? This trust? Well, what's in the trust? I don't know. And then you go to the trustee, says, well, I'm not going to tell you. And if they get through, well, it's an LLC. Well, who owns the LLC? Well, we're not going to tell you. There's a process there. Yeah,
the layers. And I guess a few weeks ago, I actually had a New York farm client who asked me about, we've set up 2 LLCs. He was talking about having a marketing arm as well. I think it's prudent for some farms to think about that. I mean, it definitely adds administrative overhead, so it's not for everybody. But
right.
I think it makes sense for some families. So when should farmers and ranchers get an estate plan? Is it too early?
The best example, a friend of yours and mine both, Shannon Farrell, his brother, he talks about how his brother died unexpectedly and he was running his parents' operation. But for Twitter and a couple other random phone calls, he would not have even known where some of the assets of the operation were, because the brother had everything on his phone. He died unexpectedly. The phone was then taken as part of the autopsy and not released. So it's never too early to have a plan in place for what's going to go on. I like to remind single adults that if they really love their parents and they just want to give it all back to them, don't have a plan. And that seems to motivate quite a few of them to do something different, because they realize that just puts a burden back on their parents, and then maybe that screws up some of their planning. But as far as a business operation, the best time to decide when you're going to exit a business is the day you form the business. Especially if you've got non-family members as partners, or with family members, I guess, too, because when you're forming the business, the world is sunny and bright and full of rainbows and unicorns. And so the exit plan on how we're going to stop working with each other is a lot easier to talk about than when you're honked off at your partner because you don't feel they made the last capital call, even though it's, or voted against your opportunity, and then you're snorted off. That's difficult to then divide up the joint enterprise. So those things need to happen early in the process.
So Pat, why do you think sometimes it's so hard to get clients just to get it done with the estate planning?
I have one client who made a estate plan, and medical professional, well-heeled, and then it sat in my office for 6 months, and I pestered her about it. And one day out of the blue, she came in. I didn't even know she had an appointment. She came in, she signed it, and she said, "Great. See, now, because my youngest is 18, now I can die, and God wouldn't kill me until I had my estate plan done." And I'm like, I don't think it's really how that works. But we have a lot of people that don't want to talk about mortality. There's a 100% chance you're going to die. It's a fact. But people like to put it off, or they don't want to talk about it, or it tears up some feelings that they don't necessarily want to address. I don't know. I saw Mad Men last night. I was watching an old episode, and the dad of one of the characters, like, "Here's my estate plan." She says, "Well, I don't want to talk about it. It makes me uncomfortable." He says, "Well, I don't either. Here it is. I've told you. Now I never have to talk about it again either."
Wow.
Not very healthy.
Yeah. Some families are like that. I guess even just for my own farm family, my parents recently redid their estate plan, and so I'm wanting to actually get all the documents. Let's all sit around at the kitchen table and let's talk about a game plan. But I think it's really hard to get families to want to do that.
Hey, we've had some success with where we'll invite the families to come in. We've got the office we use, an old Victorian kind of house, and it's got a big open conference room next to it because it used to be a photo studio for a while.
Mm-hmm.
It's got a very large conference room in there. So what we do is we invite the family members to come in after we got the plan done, and we try to do it without the in-laws, and we just walk through the whole plan of, this is the stress test, this is what happens when mom or dad dies, this is when the second happens, and we'll illustrate it and go through with that. And people say, this is great, I'm glad to know this. But then additionally, sometimes it's the first time the family's been together without in-laws in quite a while. And that would be healthy to get things done. Not that I'm dissing on in-laws, but sometimes there are things that aren't said or shouldn't be said, and they get said. So
yeah, I didn't even think about that. You bring up a great point. Like, you can't just have this on after Thanksgiving dinner sometimes. I mean, you want to have it without, the married spouses and things.
Yeah, and I think, Farrell and Derek Davies talk about that sometimes too. They talk about you can't have a family team meeting at the place where you shove Cheerios up your nose. Everybody sits at the same spot they did when they were a kid if you're eating Thanksgiving dinner. So, it's important to have kind of a place to talk and get it shot through.
Yeah. I also feel like it's really hard for people to feel a sense of urgency with the estate plan, and life just gets very busy, and it's so easy to put off to another day. I always tell people that the only reason why I even have an estate plan, because I had to calendar it and treat it like any other client deadline, and I barely made the deadline, so anyway.
Yeah. I had a guy who came in, he was in here an hour ago, and he said the only reason he came in is because he almost got killed last week at an uncontrolled intersection. Yep. So, okay. So whatever it takes. I firmly believe that lawyers should secretly funnel money to travel agencies and have them in their towns, because we get a lot of work I'm going to go to Barbados or wherever it is they're going, so I need my will done because suddenly the airplane is more dangerous. So yeah, it takes a while to get people off of dead center about it. So.
So let's say you finally have a client who's had those tough conversations. They're ready to get going on it. What are some special concerns that you think that farm families really need to address in their estate plan?
Well, first of all, I think continuity of who's got access to things in the event of an untimely death, who can sign, who really owns that account. We seem to have problems with that. Number two is going to the FSA office and certifying programs, and who can do that, who knows what's going on, who knows even the basics of what fields are planted to what anymore, with the different numbers and the varieties of grains that are getting planted. You should have a rough idea when you're going to harvest what, in what order. If that knowledge is all contained in the senior's mind, and she doesn't share it with anybody or he doesn't share it with anybody, you're putting the continuity of the operation at risk. And I'm not saying you need to, publish it on Facebook what you planted where and how much, but somebody ought to be able to access that information and help the survivors make those determinations. So that's different than most other businesses where they can get access to the accounts receivable or call whoever it is on when the next shipment of stuff is coming. Farming's a little different in that regard. I think the other thing farm families need to look at is equipment and how much of it and how long they need to continue to have it. It used to be that they just used up equipment, you put it in the tree line and it disappeared one day and that was the end of it. Now we're buying 12, 16-row planters and we're putting precision meters on them and we're putting GPS controls. Those things cost money and time, and if the elder generation is investing in those things, how long do they plan on using them? How are they going to transition that? Passwords. Todd Jansen always talks about big data and ag data, that kind of stuff. Those things have to be there, and I think a lot of farm families just don't think about that because we've kind of backed our way into some of the technology things. We don't go to buy a tractor and say, okay, well, here's the GPS monitor and here's the yield monitor system. We buy those as separate components, and then we're not consistent with our passwords and things like that. So I think farm families have a unique challenge too with rental contracts and relationships, because a lot of ground is rented. How do you maintain those relationships? How do you transition them over? I talked to one farmer who was pretty irritated that his son was not going to have a graduation party, and the son's like, well, I graduated high school. It's just kind of expected. I don't think I should have to have one. And his point was, the neighborhood's going to be there. And if you think you're going to transition into taking on this operation, you probably ought to start establishing your own individual relationships with these folks who we rent from or may rent from. And I think that gets lost sometime between generations. They think, well, because dad's always gotten to rent this farm, I'm going to be able to continue to rent that farm. And if you don't establish your own relationship with those folks, you may not.
Yeah, that's a great point for transition planning. By the way, as you know, I do family and matrimonial law. So let's talk about the big D, and I don't mean Dallas. And so how does farm estate planning, how does divorce affect that? And then also, what do you see the overlap between prenups and postnups with farm estate planning?
Well, first of all, nothing says I love you like a prenup. It's important.
Exactly.
And,
it's romantic.
Yeah, it is. We have a 99-cent movie theater here in town, and we do some advertising on it. It's a nonprofit thing. In February, I'll run I've got a slide. It says, nothing says I love you like a prenup. So I get pretty good reaction to it. But I think that's important. Iowa,
I'm still looking for, one guy to get down on one knee and say, baby, will you sign a prenup with me? So.
Right. Yeah. Keep the binoculars out and field. But it's important because it's an important tool for a family to get past that. Oh, she's marrying in because she wants in on the operation, or he's marrying in because his dad didn't make it on his. There's some important political considerations, that you can use that prenup for. I do think that in the estate planning context, I always try to make sure people understand that we transition stuff and estate planning stuff, it goes to blood, and first and foremost, and we try to avoid the in-laws in that regard. Again, not dissing on them, not minimizing there, but it's very difficult and to deal with that issue when there's that perception that, well, what if my family member dies and then the inheriting family member is going to run off with it and marry the pool boy and all that stuff. We talk about at some point you need to let go of the asset. If you're going to, in your transition plan, it becomes the other person's asset and they're free to risk it and put that capital risk, just like you did in the 60s when you bought it and your dad didn't get to tell you what to do because you bought it on your own. And if you're truly putting that asset, then it is a risk, and that couple that are taking it, it's going to be their asset. You can do some stuff on titling to make sure that it's on their side of the ledger if there's a divorce. But there's some things there that you can do from the estate planning standpoint. But absent having some dead hand control with a trust, at some point you have to let go of that asset if it's going to go down and let them make their decisions with it. But I always try to make sure that if they're gifting something, they give it just to their child and not both of them. I specifically had this problem a number of years ago where the father said, we'll put them both on there. It's just the three of us. It's my son and his wife and me, and that's all there is. And that way, if he dies, she doesn't have to do probate. And so, well, I'm not really keen on doing that. And he insisted, and I made him sign an affidavit saying that it was his directive, that I wasn't, putting her on there. It was out of convenience and to skip the step. And it was like a year later, and that they'd been married for 20 years or something. A year later, she went to her high school class reunion, found her high school sweetheart, gone. And so her name was on that farm, and specifically said don't. So, but in a stroke of good fortune, she's like, nope, don't want anything to do with it, and stayed away from it. But there's the divorce creates a whole nother level of entertainment.
Yeah, it does. And the farmland, the livestock, the equipment or assets, potentially their marital assets. They could also be non-marital assets. So the prenup or postnup could address specifically what they are. But then the farm is also a business. And then the question is a business subject to equitable distribution in a divorce? And so I oftentimes in a prenup like to define the business itself as also being non-marital property. I know some families like to negotiate vesting periods for the length of the marriage and so on and so forth. But I think all these things need to be discussed.
Yeah, absolutely. And if you don't, you end up, there's a case here in Iowa. I ended up, I was the receiver for it, the tail end of it, but the divorce court declined to split the LLC that the couple owned together.
Wow.
So 9 years later, the action to split the LLC finally got resolved. I mean, it's terrible because they essentially relitigated their divorce all over again as partners. And so that's an example. And as a result, I think the farm lost some economic opportunity, probably set it back, a good number of years on what it could be doing and growing, because it paid outrageous attorney's fees to the receiver, that not me, the receiver before me, but there was a receiver and a receiver's attorney. They got a hefty chunk of money. And then there's also a forensic accounting that went on, and that was a substantial sum of money, all because the parties were sure the other one had misconduct. And had that been addressed, or had some buy-sells or something, but as a result, it took a lot of capital to get that resolved.
So when you're doing farm estate planning for a multi-generational farm family, do different parties need to have their own attorney? For example, do the grandparents need to have a different attorney than the parents versus the grandchildren, who are all at different stages of their life, obviously with different interests?
I think, from the standpoint of, you need to identify who your client is and who you represent. And that's the first thing. And sometimes it makes sense. And if there's the right of acknowledgments and waivers and all that stuff, you can work for a family unit, but you got to understand that when the next generation may not have those same goals. And if there's any kind of true negotiation stuff that's happening and you're advocating, you can't serve more than one person. It would be great to have a family attorney. And then if individuals have got individual things they need to take care of and go elsewhere, it's, there's a professor when I went to law school back in the Stone Ages that was pressing for the idea that husband and wives, you should send the wife across the street and you should just do the husbands. And, I don't think that's common practice in Iowa. I think, from I suppose a super highly definitional version of the rules, you could look at and say, well, maybe that's, the case. But I think as long as I've done some research on that, and as long as there's I've seen some court cases around different states where you don't owe a duty to the other generation to tell them that the previous generation, for example, changed the plan.
Oh, interesting. Yeah.
But it does put you in an awkward situation at the grocery store, when you have to see them. So I think you probably run into that more now that you're in Illinois than you probably did in New York. But you run into clients in other spots. I can't pick up a pizza in town without answering legal questions. So
yeah, I feel your pain on that one. So let's go back to that multi-generational farm family who has different perspectives, different goals, etc. As you know, I'm a trained mediator. I do a lot of matrimonial, divorce mediation. I also do some commercial and agriculture mediation. I've yet to do mediation in the estate planning context. But I was curious if you had any experience with that, with mediation.
I don't know about necessarily mediation prior to the lawsuit, but we've certainly done some once the lawsuits get filed. Iowa State has a farm mediation service program that they've got put together. It takes a little bit of time, and I have not been able to find a time in my schedule to go through it with John Baker and the group up there. But it's difficult because I like to tell people everybody gets along till mom and dad die, and then you start to remember whose prom date, who got a swirly, who got punched on the stairs. I mean, and there's some retribution that comes back. I've had people say things like, well, I picked up rock on that farm, which I don't know in Illinois if you've got that, but over here in this specific part of Iowa, there seems to be a crop of rock that comes up every year that you got to pull back out of the field, otherwise your combine will eat it. So that's a common task for high school kids, or in junior high kids. If that's their last contribution on the farm and they're now in their mid-50s versus somebody who's been on the farm, rewired hog drinks in the middle of winter, forego Christmas vacations because they got to stay home and milk, those things like that. When those two siblings sit down at a table and are upset because the one who stayed home is getting treated differently than the one that left, and their number one point is, well, I picked up rock on that farm 20 years ago, 30 years ago. I'm entitled to my proportionate share. It's a difficult position to even begin to try to mediate people's expectations from, because we have such a non-standard look at dirt, and dirt is different, and soil, dirt's what's behind your ear, but it is different. It really is, and people view the land differently than they do other assets, so it makes mediation super hard. So in farms, almost always there's land involved, and that makes those resolutions difficult.
So let's say that multi-generational farm family finally gets it done. What do you advise your clients for reviewing their estate plan? Should they do it annually, every 3 years, every 10 years? What should they do?
Well, the quick answer is we try to do about every 5, but there's also the D events, the death, disassociation, like getting fired, disability, divorce, and disassociation, meaning somebody's left the operations or departure. Those D events are triggers to come along, because if you look at a well-crafted plan and you've got this set up and these people are going to get the rights to purchase and this is going to happen here, and then somebody falls off a motorcycle and now is on Social Security disability, on state aid, you certainly don't want to provide them assets when the elder generation dies, because all you're going to do is screw up their state aid. And I don't mean that from a grasping, maximizing government benefits standpoint, but I like to point out to people, imagine like some of my clients have adult children with Down syndrome, and they're highly functioning. They live in a group home. They've got their schedule. They got their jobs. They do what they're doing. And then without a well-crafted estate plan, you dump in a bunch of money to them. Now suddenly they're not eligible for that housing. Now they're not eligible maybe for some programming. And so now not only have they lost their parents, which is a source of support to them, but now their extended social network has been upended on them, all because you didn't stop to think about what you were doing, or you mandated, oh, it's got to be fair. They got to have a percentage. You're not treating them equitably. So those are things to look at.
So Pat, we've got listeners from coast to coast. How can people find a farm estate planning attorney near them that can help guide them through the process? What advice do you have for them?
There's a great group. Shameless plug. I'm a board member of the American Agricultural Law Association. Their next annual meeting is going to be out in Portland here in just a little bit, but it has the opportunity to look by your area. Now, that doesn't mean that they're the only people that understand farming. And there are lots of different ag practitioners in the world. There's those that work with food. There's those that work with production groups. There's a wide variety. But I think most importantly is you look at those resources, and that one you can at least get somebody that if you say Roundup, they know that you may be talking about a chemical and just not. So, and there's a lot of really good attorneys out there that do estate planning stuff that have nothing to do with ag, and they don't understand the subtleties and the difference. I do think it's worth finding an ag-based attorney that can understand your industry, and I think that goes for a lot of different industries. I know somebody who just is signed a contract with the NFL. He's just a rookie. I don't want anything to do with that contract. I don't know sports law. I don't know how that stuff works. And I don't even know the terminology. And so I think that's a life lesson that everybody who's listening, regardless of whether or not they're operating a farm or if they're just in love with your podcast, that can take and make sure that they find the right kind of advisors for their industry and their world.
Yeah, I think the American Ag Law Association is a fantastic resource for our listeners. And I think, Pat, that's where we met originally at some annual conference many moons ago.
Yeah, that sounds about right. I've met a lot of good people from all over. It's interesting in Iowa and I'm sure in Illinois too. Tile and tile drainage, that's a big deal, and tile easements. In Texas, they're trying to find water. So discussing with them about the things they fight about water rights versus, we're actually trying to get rid of the water. It helps broaden your perspective and makes you a more well-rounded ag attorney.
So Pat, once again, why don't you tell everybody the name of the book, where to look for it, and also give your contact information for our listeners.
Okay, so it's Pat Dillon. I'm at dillonlawpc.com. The book is Field Manual, Iowa Farmer's Guide to Legal Issues. Sure, you can find it on Amazon, or you can order it directly from me. I'll make sure you get it. We've got a website. We put up some blog posts up there, and a lot of times they're just my perception or my commentary on what else is going on in the ag world. That also gets published in the local newspaper. So it's focused for not necessarily other lawyers. It's more focused for people that just want to understand the basic concepts of what's going on.
I think that's where you really excel, Pat. And you do such a great job really taking down complex legal issues and to just layman speak. I still remember to this day, I don't know if you remember it, you were talked a lot about business organizations and how corporations are like a suit and tie and LLCs are business casual. And what would you say were partnerships? Are these jeans and t-shirt?
yeah, we were down solo practitioners, jeans and t-shirt, and then we had a sport coat level in there, and we had I like doing that, and I don't know why I've developed that kind of way of doing things, but actually I enjoy that, and having people understand things in simple terms helps people make better decisions. So. Yeah,
absolutely. Well, thanks so much for your time and expertise, Pat, and looking forward to seeing you in Portland.
All right, we'll see you there. Thanks again.
All right, bye-bye. All right, this next question comes to us from a producer in Michigan. He asks, what is this thing about adverse possession? I might have an issue with my neighbor right now. Well, the law of adverse possession, it's an area of property law. This varies from state to state, but generally speaking, a plaintiff in an adverse possession case must prove a couple elements. 1, hostile, 2, actual, 3, open, 4, exclusive, 5, continuous, and all this has to take place for a period of 10 years in most states, or whatever the statute of limitations is in your state. So what the heck am I talking about? So if this producer in Michigan has a neighbor who has been reaching all these elements, using a piece of his property, perhaps been, running cattle on part of his property or whatever it is, and he's acting like it's his own property, this might perhaps be a situation where the other adjacent owner could take ownership of that land through adverse possession. It's a very interesting concept if you think about it, that you could actually own land and it could be taken from you by a neighbor if they are centrally hostile and they're doing it openly and exclusively and continuously for 10 years. They can actually take that land from you. So let's break down these elements one by one. And of course, like always, if you have, I'm not licensed in the state of Michigan, so I would recommend to this listener to please speak to an attorney licensed in your jurisdiction. So, all right, let's break down these elements one by one. The first one is the hostile possession. So this refers to words or acts. They're not doing it passively. They're not doing it secretively, but they're doing it with words or acts that make another person believe that they believe that this land is theirs. Okay. So if your neighbor knows you cut through his yard and waves at you when you do it, then this isn't hostile. Okay. So the second element is actual possession. So the claimant need not live upon the land and close it with fences or stand guard in order for there to be actual possession. It is enough if the claimant treats the property like his or her own ground. So I myself have a farm in central Illinois. I call it Carrie's farm. I've got my steers and my goats and my chickens and a few bunny rabbits and things like that. And I have an adjacent landowner, and there is a bunch of trees between our property. Okay. So if I start acting like that row of trees is on my property line, I cut down the trees, I plant new trees, I am mowing around that land, that is actual possession. So it is not actual possession if, the person who comes and mows my yard every week stays clear of that tree line, because I know that those trees are actually on my neighbor's property. The next element is open and notorious. All right. So this requires proof that the true owner is aware that somebody else is claiming the ground, right? So use the example, and I don't know the specifics of this gentleman in Michigan and what he's dealing with right now, but let's just say that there's cattle that are being run on his property, okay? And he knows it, all right? So he is risking adverse possession because he is aware, or the law would say that you should be aware that somebody is using your land. All right. The next element is exclusive possession. So this can't necessarily be mixed. So it's usually exclusive. So going back to the example of somebody running cattle on the land. So let's just say they're running it on a parcel. They built up a temporary fence, and there's no other livestock that are being run on that parcel. That would be exclusive possession. So going back to my own example with the neighbor, so I've got the line of trees. So, in that instance, I tear down the trees, I plant new trees, I'm mowing the trees. My neighbors aren't really taking care of it. They're essentially giving me access to run that strip of land. And if I do that for, depending on the state, 10 years, then that strip of land could then be mine under the law of adverse possession. So it's a quirky area of law, but these are, again, the elements that need to be met: hostile, actual, open, exclusive, continuous, for whatever the period of time is in your state, typically 10 years. So that's this question for Ask Carrie. If you have a question that you would like for me to address on an upcoming episode of Ag Law Today, please be sure to email me at carrie@rinkerlaw.com. Put Ask Carrie in the subject line so I know that you're referencing this podcast. It's Carrie, Cari, @rinkerlaw.com, spelled RINCKERLAW.com. If you go to rinkerlaw.com, it also has the links to all my various social media platforms that I'm on, including Twitter, Facebook, LinkedIn, Snapchat, Instagram, and YouTube. While you're there, make sure to also subscribe to Ag Law Today on YouTube, and you can also find us on iTunes. Looking forward to the conversation. See you there.